Even if your lordship strike it down, they may bring it back in another avatar. Your lordship will strike down this one. They will bring the same dominance of the executive in another avatar to the facts of this case. And therefore, my lord, in my respectful submission, this needs to be struck down. Actually, matter came up to the court many times, again and again, similar, actually, like this matter, because now my fear is, even if your lordship strike it down, they may bring it back in another avatar. Your lordship will strike down this one. They will bring the same dominance of the executive in another avatar, saying, Prime Minister, Speaker, Chairman of the Raj Sabha, and Leader of Opposition. Suppose they bring that. Again, my lord, there will be executive dominance, because essentially the Speaker and the Chairman of the Raj Sabha are also appointed by the executive, virtually. So, same thing was happening. Again and again they were making rules, even despite your lordship's judgments about appointment of members of the tribunals, etc. And again this court had to repeatedly strike them down. In Madras Bar Association 1, Madras Bar Association 2, Roger Matthew, where a constitution bench did that. Thereafter, then we have said that the central government to whom rule-making authority was conferred by Section 184 has not observed the principles which were enunciated in Madras Bar Association and Bar Association, either in letter or in spirit. The dangers inherent in conferring such an unguided power on the executive to frame rules governing the selection, appointment and conditions of service of members of tribunals is evident from the rules which have been framed. Basing my arguments on Anup Baranwal, I am saying that dehorse Anup Baranwal. Even otherwise, all those principles which the courts have enunciated, with the constitution benches of this court has enunciated in so many judgments. Scora 1, Scora 2, that is NJAC, then this Roger Matthew, then that Central Railway Organizations on Arbitration Tribunal. Exactly all those principles apply squarely to the facts of this case. And therefore, my lord, in my respectful submission, this needs to be struck down. And as I said, my lord, my fear is...
We can't do...
No, your lordship can do something. Can do. So your lordship can now go one step further. So one step further. I'm not saying that your lordship should prescribe exactly what should be the law made by. I'm not saying that. What I am saying is that your lordship can say that whatever body they make cannot have people whose appointment in turn, or if they have people whose appointment in turn depends upon the executive, that will vitiate the same principle. So, for example, the Speaker, the Vice President, their appointment is squarely in the hands of the executive. So, therefore, that your lordship can, and in my respectful submission, should say, because otherwise we keep coming back to square one. And that's what happened. So, this is a principle which, Lord, has been reiterated in a very large number of cases. These are all Constitution bench judgments. I am only reading Constitution bench judgments, where they have said that, look, where you have a body which has a judicial or a quasi-judicial role, then you cannot have the appointments of that body, of members of that body, being controlled or dominantly controlled by the executive. Or in fact, in NJAC, they said even significantly influenced by the executive. Then that will destroy the independence of that body, because the government is a major litigant, just as, my lord, the government or the political party in power is a major stakeholder before the Election Commission. Then, my lord, page 22, the Election Commission, para 13, entrusted with the constitutional responsibility of conducting free and fair elections, occupies a position no less vital in a democratic framework. The Commission exercises vast constitutional powers, performs adjudicatory and quasi-judicial functions, and is routinely called upon to decide issues directly affecting the political fortunes of the ruling dispensation itself. In such circumstances, any appointment mechanism which confers exclusive or overwhelming control upon the executive gravely compromises both the actual independence of the Commission and the perception of its neutrality. In institutions discharging constitutional, adjudicatory, and supervisory functions, legitimacy rests not merely upon actual independence, but equally upon the public perception of institutional neutrality. Even a reasonable apprehension that appointments are controlled by the political executive is sufficient to erode public confidence in the impartiality of the Election Commission. Constitutional democracy requires that not only elections be free and fair, but they must manifestly appear to be so. And then, my lord, para 16, the impugned section 7 creates a selection committee structurally dominated by the political executive, consisting of the Prime Minister and a Union Cabinet Minister nominated by the Prime Minister. The consequence of such composition is that the ruling dispensation effectively acquires decisive control over appointments of the EC. This creates a manifest danger of institutional bias, as the party, which is itself the principal stakeholder in electoral contests, is empowered to determine the composition of the constitutional authority charged with supervising those very elections. This court has consistently held that where one party to a dispute or process retains unilateral or dominant control over the constitution of an adjudicatory body, the resulting mechanism becomes constitutionally suspect, violating the principles of equality, fairness, and institutional impartiality under Article 14. Then, my lord, then came this case, Central Organization for Railway Electrification, which was regarding arbitration. And again, this is a Constitution bench judgment. I'll only read a few paragraphs. If your lordship turns to page 24, para 75, at the bottom. Independence and impartiality of arbitral proceedings and equality of parties are concomitant principles. The independence and impartiality of arbitral proceedings can be effectively enforced only if the parties can participate equally at all stages of an arbitral process. Therefore, the principle of equal treatment of parties applies at all stages of arbitral proceedings, including the stage of appointment of arbitrators. Then para 88. The principle governing